We all like to think that legal procedures are there to guarantee a fair fight, right? But what happens when those very rules, the ones designed to create order, actually end up creating a massive injustice? Well, today, we're going to dive deep into a legal case that asks that exact question, and we'll see how the system's own architecture can sometimes become the biggest roadblock to finding the truth.
So to really get into this, we're going to look at the story of an Idaho homeowner named Jeremy Bass. His high-stakes foreclosure case turned into this huge battle, not just over his house, but over what procedural fairness is even supposed to mean.
So here's the setup for you. You've got Jeremy Bass, and he's representing himself, what the courts call pro se. And he's going up against not one, but two big corporate entities in a super complex case. It's a classic David versus Goliath story. Except in this version, Goliath's weapon is the legal rulebook itself.
Okay, let's start at the exact moment that Jeremy Bass got caught in this procedural trap. It all boiled down to one critical hearing and a few chaotic days that gave him what a legal expert later called an impossible choice.
Just look at this timeline. It's a total pressure cooker. On a Friday, the other side files their final brief, and according to Bass, they sneak in all new arguments. This forces him to work through the entire weekend, scrambling to file a response by Monday. And the very next day, Tuesday, is the big make-or-break hearing. I mean, that's just 4 days, including a weekend, to counter what felt like a last-minute ambush.
This quote from legal ethics professor Elizabeth Morgan just nails the dilemma Bass was in. It's a catch-22, right? He could either file a response and risk the judge saying, hey, you broke the rules, or he could just stay quiet and let these brand new claims go completely unchallenged right before the decision. He chose to fight back.
So, Bass makes his move and files his response. How did the court react? Well, the judge's response was fast, it was final, and it created what was basically an impenetrable procedural wall.
Now, to get why the judge ruled this way, you gotta understand this standard playbook for court filings in Idaho. It's supposed to be a simple 3-step dance. Step 1, a party files a motion. Step 2, the other side files their opposition. And Step 3, the first party gets the last word with one final reply. Motion, opposition, reply. That's it. There is no Step 4 in the rulebook.
And there it is, the judge's own words from that hearing. The procedural gate just slams shut. Because a reply to a reply, what lawyers sometimes call a sur-reply, isn't explicitly written down in the rules, the court flat out refused to even look at the documents Bass had worked all weekend to prepare. Just like that, his evidence was off the table.
This whole situation created what some legal analysts have called the reply void. It's basically a procedural black hole. It's a loophole where one side can drop new arguments in their very last filing, but the rules give the other side no official way to answer. You're just silenced.
Okay, but here's the real kicker. Just a few weeks before strictly enforcing this rule against a guy representing himself, the very same judge had admitted in open court that the rule in question was, and I'm quoting here, a little convoluted. You know, it just shows you how incredibly hard it is for any regular person to try and navigate this system.
You know, this whole mess really pulls back the curtain on a deep tension in our legal system. It's a clash between two fundamentally different ways of thinking about what justice is and how the rules are supposed to work.
So, on one hand, you have the textualist approach. That's what the court did here. It's all about sticking to the exact written word of the law. If the rulebook doesn't mention a sur-reply, then it doesn't exist. Period. This makes the system predictable. But on the other side, you have the purposivist approach. This view says, hey, let's focus on the purpose of the rules, which is to get to a fair result. A technicality shouldn't be used as a weapon to block the court from seeing crucial evidence.
So what was the actual cost of this procedural ruling? What was in those documents that the judge refused to even open? This is where the story gets really interesting.
Yeah, this wasn't just some minor argument over rules. Bass was convinced that the information in his rejected files could have changed the entire outcome of his case. So what was this bombshell evidence that the court never saw? This was it. This was the quote. In a document submitted by the plaintiffs themselves, they straight up admitted to contacting the auction trustee before the sale to find out what the lender's opening bid was going to be. To Bass, this was the smoking gun.
So why does that matter so much? Well, under Idaho law, to be a legitimate buyer at a foreclosure auction, you have to be a good faith purchaser. That means you can't have an unfair advantage. Bass argued that getting inside info on the opening bid before anyone else, well, that's a form of coordination that could disqualify them. And if they weren't good faith purchasers, the whole sale could potentially be thrown out.
But the story doesn't even end there. When Bass later asked the court to reconsider its decision, he hit yet another wall. Analysts call this a recursive barrier. The court basically said, well, we can't consider your evidence because you didn't bring it up at the hearing. But of course, he couldn't bring it up at the hearing because the court had already said it wouldn't consider it. It's a perfect, unbreakable, circular trap.
So the Jeremy Bass case, while it's about one person, it really shines a bright light on a potential systemic issue. The big question is, how do we fix this reply void so this doesn't keep happening to other people? Let's check out some of the solutions on the table.
It turns out Idaho isn't the first place to deal with this. Other legal systems have already found ways to handle it. For instance, in federal courts, you can ask the judge for permission to file that extra response. Other courts allow something called a motion to strike, which is basically asking the judge to just ignore any new arguments that pop up in a final reply. The point is, clear solutions already exist out there.
So, based on what works elsewhere, legal reformers have a pretty clear list of fixes for Idaho. You could just change the rules to allow these extra replies when new stuff is brought up. Or you could get tough on the other side and just refuse to consider any final briefs that try to sneak in new arguments. And maybe most importantly, you could build some flexibility into the rules for people who are representing themselves and don't have a lawyer to navigate all this.
Ultimately, this quote from Dr. Rachel Montgomery really gets to the heart of everything we've been talking about. The whole point of having courts and all these rules is to get to the truth and resolve things fairly. When procedure gets in the way of that, you have to ask if the system itself is failing.
And that's really the biggest takeaway here. We tend to think of procedure as the boring, technical stuff, right? The fine print. But as this case shows so clearly, procedure isn't separate from justice. It can actually determine the outcome. The rules of the game can decide who wins and who loses before the real issues are even debated.
Which leaves us with this final, really critical question. It's that constant tension between predictability and fairness. Should a judge be a strict umpire who can only enforce the rulebook exactly as it's written, even if it leads to a result that feels wrong? Or should they have the flexibility to bend a rule to make sure the whole point of the law, which is to be fair, is actually served? There's no easy answer, but it's a question that cases like this force us all to think about.